Hello, my name is Caitlin O'Neill, and today I'll be talking about workplace protection for lesbian, gay, bisexual, and transgender employees. From here on out, they will be referred to as LGBT. All across the country, same-sex marriage is being legalized, which is a huge step forward for America's society as a whole. However, while these laws are being passed, there is something that has been lacking. There are still not laws in all 50 states that exist protecting LGBT employees from discrimination. Currently, there are 29 states that do not have laws that protect LGBT employees from prejudice in the workplace. To put it blatantly, someone can be fired just for being gay, and there's nothing they can do about it. Truly, it is astounding that in today's day and age, LGBT are not a protected class of people, considering the extreme amounts of discrimination that occurs on a regular basis. For instance, a woman named Vandy Beth Glenn was fired from her job at Georgia General Assembly for being transgender. Glenn says, "My boss told me I would make other people uncomfortable just by being myself. He told me that my transition was unacceptable, and over he told me it was inappropriate. Then he fired me. I was escorted back to my desk, told to clean it out, and then marched out of the building. I was devastated." There is no federal law protecting LGBT employees from discrimination in the private sector. Currently, state-by-state laws do exist, as well as company-by-company policies. However, what really needs to happen is the Employee Non-Discrimination Act needs to be written into law. The Employee Non-Discrimination Act was passed through the Senate almost a year ago. However, it has not been brought to a vote in the House of Representatives. Also, in July 2014, President Obama signed 2 executive orders protecting LGBT workers. The first protecting federal transgender employees from workplace discrimination, and the second prohibiting federal contractors from discriminating on the basis of sexual orientation or gender identity. While these executive orders are important, there is still no federal law that protects individuals in the private sector. Currently, in the last month, a conservative Texas lawmaker has been trying to pass a state constitutional amendment that would allow businesses to refuse to serve LGBT customers on the basis of religious belief. State Senator Donna Campbell, pictured here, is trying to pass a law that would essentially be licensed to discriminate and would allow small business owners to deny service to those who are LGBT. Another motivation for the law is religion, as a justification to fire or avoid hiring LGBT employees. A percentage of gay individuals have faced some form of discrimination and harassment in the workplace, as well as a large portion of transgender employees. Let me give you some exact numbers. 7 to 41% of gay and transgender workers have been verbally or physically abused while at work. There is no official federal statute that protects employees in the private sector against workplace discrimination or harassment based on sexual orientation or gender identity. The closest current act to that is the Employment Non-Discrimination Act, which has been previously mentioned, and that would provide basic protections against workplace discrimination on the basis of sexual orientation or gender identity. This bill is very similarly modeled after current civil rights laws, including Title VII of the Civil Rights Act of 1964 and the Americans with Disabilities Act. The Employment Non-Discrimination Act prohibits preferential treatment as well as quotas and does not permit disparate impact suits. This bill also exempts small businesses, the military, and religious organizations. State laws also currently exist, protecting against discrimination. In 20 states and Washington, D.C., there are laws that protect against sexual orientation discrimination in both private and public workplaces. Some states only prohibit sexual orientation discrimination in only public workplaces. Additionally, there are 12 states and Washington, D.C. that have laws that protect against gender identity workplace discrimination. Sometimes in states without gender identity discrimination statutes, courts have used other anti-discrimination statutes, like gender discrimination, to include gender identity. Company policies are also in place. Many companies have policies that prohibit discrimination based on sexual orientation and gender identity. By law, these policies can be more, but not less, stringent than the state or local law standards. A federal statute needs to be made into law that helps LGBT employees be treated fairly, equally, and with dignity. Currently, LGBT employees experience wage gaps, wrongful termination, they're passed over for promotions, and they are denied employment. Gay men earn 10 to 32% less than similarly qualified heterosexual men. 13 to 56% of transgendered employees have reported wrongful termination and been fired based on their gender identity. 10 to 28% of LGBT employees have been denied a promotion, and 19% of transgendered employees have been denied a promotion. 8 to 17% of LGBT employees have been denied employment, and 13 to 47% of transgender employees have been denied employment. In a survey that was conducted of 17 states that was performed in 2007 by the Williams Institute, it was found that complaints are consistently filed by lesbian, gay, and bisexual employees for discrimination and harassment. Complaints are filed at similar rates by LGBT employees as complaints filed for race or for sex discrimination. Complaints that are filed by LGBT employees at the same rate as sex discrimination by female workers, which is at about a rate of 5 complaints per every 10,000 workers. Complaints are filed at a slightly lesser rate than race complaints, which are filed at about a rate of about 7 complaints for every 10,000 workers. Lesbian, gay, and bisexual employees are subject to harassment time and time again. In the conclusion of the article, Evidence of Employment Discrimination on the Basis of Sexual Orientation and Gender Identity, which discusses the 2007 survey, it is said the data suggests that sexual orientation and employment protections are necessary. Employers can be and should be held liable if they fail to protect employees from harassment based on sexual orientation. This is a conclusion of the case Louis Bettino v. Birkin Manufacturing Company. Louis Bettino sued Birkin Manufacturing Company for failing to protect their employee from verbal harassment that took place over the course of several years. Bettino was called derogatory terms and was subject to slurs in English, Spanish, and Italian. The Connecticut Supreme Court ruled employers can be liable if they fail to protect their employees from harassment based on sexual orientation, and the court also upheld a jury award of $95,000 in favor of plaintiff Louis Bettino. Being transgender is not grounds to harass someone and create inferior work conditions so severe the employee must leave the job. This is the conclusion from the case Barreto Nito v. Town of Hardwick Police Department. Anthony Barreto Nito sued the Town of Hardwick, Vermont's police department for purposeful extreme harassment that led him to quit his job. Shortly after Barreto Nito began employment with the police department, town officials found a website that described Barreto Nito as being transsexual. Based on the information, the officials deemed him unable to do the job. Barreto Nito was then subject to continuous harassment and inferior work conditions so severe that it forced him to leave his job. Gregory Rambo, a former police chief, testified in court alleging that a town official directed him to make Barreto Nito so uncomfortable that he would leave. The town of Hardwick settled the claim, which included a monetary payment to Barreto Nito, and for the town to adopt a formal policy of non-discrimination against transgender persons and train its employees on transgender issues. Transgender individuals should not be discriminated on the basis of sex identity. This is the conclusion from the case Millett v. Letco. A male-to-female transgender employee, Charlene Millett, claimed her employer Letco Inc. harassed her, subjected her to disparate treatment, and retaliated against her because she is transgender. Letco moved to dismiss the complaint based on the grounds that discrimination is based on an individual's transsexual status does not constitute sex discrimination under Massachusetts anti-discrimination statute. In the end, Millett's complaint was dismissed. However, this was a landmark victory for transgender individuals because it guaranteed that transgendered employees from then on out would be afforded protected status. All in all, a federal law must be put into place to protect LGBT employees from workplace conditions that are discriminatory in any way based on their sexual orientation or gender identity. It is time that lesbian, gay, bisexual, and transgender employees are stopped being treated like second-class citizens in the workplace, and it is time for the Employee Non-Discrimination Act to be written into law.